for the attorney-client privilege to apply, certain requirements have to be met. If you're not aware, attorney-client privilege is a legal doctrine that protects certain communications from being disclosed to third parties. For the privilege to apply, it needs to be for the purpose of obtaining legal advice. The two most concrete pieces of advice I can give you today are just CCing your attorney does not mean that it's a privileged communication. That is a very common mistake that people make. Similarly, labeling something confidential or privileged does not mean that the privilege applies. For best practices, if you want to make sure that something is privileged, you should email the attorney with an explanation, something saying, hey, seeking your advice, and then if you CC somebody else, it should probably become privileged. The privilege also does not apply to all employees. It's in Pennsylvania, it only extends to communications between attorney and agents authorized to act on the corporation's behalf. So again, similarly, if you have school counsel send an email to every employee at the school CC'd, it's going to be much harder to say that that was a privileged communication.
I think it's key there to appreciate that you can break the privilege, that you could have a communication that would otherwise have been privileged, and by who is also on that email or phone call or is joining the meeting, the privilege can be broken, right, Joe?
Yes, exactly. That is a very important thing to understand. If it's somebody outside of the organization, you have probably waived the attorney-client privilege. So it's incredibly important to be careful about who you CC on these emails and how you frame these communications generally. It's also important to understand that any personal information unrelated to school business that is given to an attorney is also not privileged or protected from disclosure. So if you as a board member email school counsel and say, hey, I'm getting sued in my personal capacity and I have $500,000 in Bitcoin, can somebody try and collect against that? That is not going to be your protected communication. And in that unrelated lawsuit, that's probably going to be an email that could be discovered or potentially used against you. Additionally, if school counsel is told something by an individual that is potentially harmful to the school's interest, the attorney then has an affirmative obligation to disclose that information to the leadership of the school. So as noted in that last bullet point, that means that heads and board members should carefully consider when they may need independent legal advice, understanding that school counsel is only representing the organization.